Welcome to Mayor Brown's International Arbitration Across the Pond podcast. Each episode is designed to provide insight on legal issues and other matters affecting international arbitration in the UK, US and around the world. The podcast is presented by two of Mayor Brown's international arbitration partners, Kwadwo Sarkodie from the firm's London office and Charles Harris from the firm's Chicago office. You can subscribe to this podcast on all major podcasting platforms, as well as Mayor Brown's YouTube channel. We hope you enjoy the podcast.
Welcome everyone to our first podcast of 2021. Happy to be here with my colleague Kwadwo Sarkodie.
Hi there, Chucky. Really good to be seeing you and to be on the podcast again for 2021.
Absolutely. So, as we've discussed, there's been a lot of interesting developments in 2021 already, and we're going to discuss one today. But before we get to that, I think the way to introduce it is something that you might have noticed I've been doing the past couple of podcasts, but kind of figuring out a name. So, I went to bed last night trying to figure out the name of this podcast, and I have something that I want to propose to you. So it's Brexited.
I want to hear it.
Brexited, finally, what that means for international arbitration. How do you like that?
That's a fantastic answer. We can live up to it with the podcast.
Right. So if everybody heard that, we're going to be talking about Brexit today. And actually what's going to happen is I'm going to be interviewing Kwadwo. And for all us in the US and elsewhere who have no idea what Brexit is, Kwadwo is going to educate us. So I'm looking forward to this discussion. Any comments before we get started?
None at all, Chucky, but just to say I'm very excited and interested to hear your take on what Brexit looks like from the outside, but also to give my perspective from here in Brexit Britain.
Okay, sounds good. So I think the first question is actually a question that many of your countrymen and countrywomen asked after they voted for the referendum, and that's what does Brexit mean? What is it? What is the EU? So you guys have been in the EU, the European Union, just not to use the acronym, but EU means European Union. You guys have been in it for 47 years. Tell us what all that means. Tell us what Brexit really means.
Well, thanks a lot, Chucky. That's an interesting question, and that's a big question. I'm not sure I can fully do it justice. But to give the overall background, the process really began with the shock of the result in the referendum back in June 2016. And that's when the political roller coaster really started. Obviously, we had the resignation of Prime Minister David Cameron. Theresa May as the new Prime Minister promising that Brexit will mean Brexit. But then she faced her own obstacles. There were court challenges. There were nail-biting votes in Parliament. She was then replaced by Boris Johnson as Prime Minister. And in December 2019, he earned a resounding electoral mandate to get Brexit done. And he set the deadline of 31st December 2020 to get Britain out of the EU, finally, once and for all. Or at least that was the way he sold it. Now, what that has now culminated following a fraught series of negotiations, which took it right to the wire, was the agreement on Christmas Eve 2020 of the EU Trade and Cooperation Agreement, or we'll call the TCA. Now, that is this overarching agreement, which on Britain's exit from the EU, in force from January 2021, that governs the new relationship and partnership of an independent country, which the UK will be, as I say, from January of this year. It's implemented in the UK by legislation called the European Union Future Relationship Act 2020. Again, that enters into force on the 1st of January 2021. So overall, Brexit is not entirely done. There remain gaps to be closed. There remain negotiations in important areas. And no doubt there will be disputes and friction because while the UK, Britain, has left the European Union, Obviously, there are key areas where trade, relationships, mutual cooperation must continue. Now, they're largely governed by the framework of this Act, but we are waiting to see precisely how all of that will work. So, in summary, in 2021, we are finally getting a bit of clarity as to what Brexit might mean.
Okay. Well, that all sounds good. It sounds interesting. It sounds like you guys got a lot going on over there. But so you talked about the TCA. You sent me a copy of it. It's 1,200 pages, and I told you I accidentally printed it out before I realized it was 1,200 pages, and my printer was going for 10 minutes, and I'm like, what's going on here? So I stopped it and I cut it off. But I did go to the sections that are important for our discussion today, which is the TCA and how it affects international arbitration. And that's kind of what our listeners want to hear today. So I want to turn to you and to start talking about that.
Thanks so much, Chucky. Yeah, so there are a number of interesting points to look at from an international arbitration perspective. You know, in addition to what you mentioned, there's the impact of Brexit on disputes before the English courts. So really considerations about the relative attractiveness for commercial disputes, and particularly cross-border commercial disputes, of using the UK courts vis-a-vis using international arbitration. There's also the question of London's continued attractiveness, or otherwise, as a seat of arbitration. And that, of course, brings in the issue of the enforceability of London-seated arbitration awards and whether there are any implications that Brexit has for that. And finally, we'll also look at the key role, as you mentioned, that arbitration plays with regard to the TCA itself, and particularly for resolving the disputes and frictions which will, at some point, undoubtedly arise as the new relationship between the UK and the EU develops.
Yeah, and I want to be clear about what we're talking about when we're talking about disputes that are kind of related to the TCA. We're not talking about private disputes. We're talking about essentially disputes between states as regarding the interpretation essentially of the TCA, right?
Absolutely.
Okay. All right. So a couple of things. So I think we want to. The first thing you mentioned is how Brexit is going to affect the English courts. So why don't we start off by having you discuss that a little bit? But in discussing that, if you can also talk about how it worked with the member states prior to UK's exit a month or so ago.
Yeah, absolutely. So the way of background, the English courts begin from a strong position. There are a series of fundamental attractions to litigating parties of the English courts, and they are not going to change regardless of Brexit. So the stable English legal system, the excellent standard of the judges, the English language, which obviously you'll probably say in the US you speak better than us, but at the end of the day, we still have that in common. And of course, the benefits of English common law. But there are arguments and potential debates about aspects in which Brexit may impose perhaps additional hurdles or additional complications. And this is, as you mentioned, concerns perhaps comparing the position prior to exit to the position now. So when the UK was part of the EU, there were certain jurisdictional rules governed by EU regulations, which took steps to ensure, for instance, that parallel proceedings before courts of different member states could be avoided, that choice of law clauses would be upheld, and so on. I'm thinking in particular about the recast Brussels regulation. Now, that applied when the UK was a member and obviously ceased to apply from January 2021. So there's a question there of where does that leave the position? Does that mean now that the risk of parallel proceedings is perhaps higher with regard to cross-border contracts where disputes arise, where perhaps the contract might provide for an English law exclusive jurisdiction clause, but a party might then sue their contracting party, or might consider it beneficial to do that, for instance, to sue in, say, the Italian courts. Now, under the position which prevailed when the UK was a member, the recast Brussels regulation governed that, and that would have upheld the jurisdiction clause providing for the English courts. Now, potentially, in certain circumstances, there may be arguments that in this case, the Italian court could decide for itself whether it had jurisdiction. Therefore, if perhaps it felt that the English law jurisdiction clause was invalid for some reason, it could assume jurisdiction. That raises the risk around parallel proceedings and so on, which wasn't there when England was within the EU. Similarly, with regard to enforcement judgment.
So you might be getting to this, but let me just cut you off there and ask you a question about that. So under the TCA, in that scenario that you gave, that there's been no decision about how the member states would now view these jurisdictional questions. Is that right? There's no conclusion on that yet.
So this particular scenario that you described is not governed by the TCA. What in fact does govern it is the Lugano Treaty. Now, this was a treaty which the UK was party to as a member of the EU. So the EU has signed this treaty in 2015. Now, of course, when the UK left the EU, it ceased to be a party to that treaty, and therefore it signed the treaty as of 1st of January 2021. So moving forward, and for agreements entered into from January onwards, the position is clear. The Lugano Treaty makes broadly similar provision to the recast Brussels regulation. The issue where the gap potentially arises is with regard to agreements entered into between 2015 and January 2021, because there is a debate which is yet to be resolved as to whether the UK's signature of the treaty is essentially backdated and has retrospective effect. Now, the EU Commission has given an opinion, which is non-binding, but it is some guidance to go on so far, to say that is not the case. So therefore, that scenario and those uncertainties that I described really arise with regard to contracts which are entered into in that sort of gap period. As years go on, and we're dealing with agreements which have been entered into from January this year onwards, that issue falls away, but that still does leave a fair amount of scope for uncertainty.
Okay, understood. Thank you for that explanation.
So moving on, there is also the issue around enforcement of judgments. Again, when the UK was a member of the EU, it was subject to treaties and regulations with regard to that. Now, the reason I mentioned that, okay, why am I discussing courts when this is about international arbitration? Mm-hmm. But what all this does is perhaps offer positive news for arbitration. It might lead to parties expressing a preference or an increased preference for an international arbitration with regard to cross-border agreements, where there's issues of enforcement potentially in the EU member states and or in the UK. If parties want to have English law, they may express perhaps a preference for perhaps a London-seated arbitration under a contract applying English law, in contrast perhaps to the governing law the governing tribunal being the English courts.
So let me staying on this point about English courts. So how about the ability post-Brexit for the English courts to support arbitration? Is that still there? Has it changed or is it different?
Well, again, the background is the very long and effective track record the English courts have shown of supporting arbitration. And there's no reason to believe any of that is going to change. The courts and the UK government are more focused than ever, I think, in the wake of Brexit, to emphasise and support the business-friendly approach of the UK, and providing effective means for arbitration is very much part of that. So the ability of English courts to enforce arbitral awards, to grant interim relief, to be effective while holding back from being excessively interfering, and therefore respecting and upholding the ability of tribunals to progress effectively, were there before Brexit and are very much there now. None of that has changed.
Okay. So another question, and moving away from the English courts. So post-Brexit, and you guys think that London is for whatever reason an attractive seat for arbitration, which I agree with. I'm being facetious. But post-Brexit, is that going to remain the same? What do you think?
Again, I think there's no reason why not. Again, similar sort of reasons. The framework provided by the English Arbitration Act 1996 focuses on upholding and supporting agreements to arbitrate. The courts recognise as I mentioned, the need for arbitration to progress smoothly and effectively. And more generally, the attractions of London. I say maybe I'm biased because I live here, but it's an excellent venue in terms of facilities, in terms of the body of solicitors and barristers who specialise in arbitration that parties have in one place on their doorstep. The presence of all the major global international arbitration institutions. The availability of sophisticated hearing facilities, technology, and so on. All of that's here in London. All of that continues to be a core part of London's overall attractiveness.
Mm-hmm. And so when we look at so switching gears slightly, so when we look at the kind of difference between when we look at the uncertainty that you talked about with the English courts, and we look at arbitration as an alternative. So as far as enforcement, is there, you talked a little bit about this, but is there a benefit to arbitration, international arbitration versus the English courts?
Well, I think the key factor there is the New York Convention. So the New York Convention, to which the UK is obviously a signatory, as are the member states of the EU, is not impacted by Brexit in any way. So its effectiveness and the ability of not just the courts of the UK, but the courts of any signatory state to uphold it and put it into effect absolutely continue. And so that is a core element of stability, I would say, with regard to international arbitration against the background of the changes brought about by Brexit. Because that mechanism, which is tried and tested, it's well known around the world, and it's been effectively and continually upheld by the English courts, remains there and remains a core part of the attractiveness of international arbitration as a dispute resolution mechanism.
So maybe people, the takeaway for me is maybe people should be looking at international arbitration as a common and familiar way to resolve disputes. So if anything, I mean, I think from what I'm hearing, international arbitration becomes more attractive to me. I don't know about it in London necessarily, but definitely more attractive.
Well, no, thanks, Chucky. That's really interesting to hear that perspective from outside the UK. You know, we're here in the Goldfish Bowl. It's always useful to hear how this is being perceived from elsewhere. But I think, international arbitration has so many fundamental attractions to it anyway. That is why it's so prevalent and important with regard to cross-border contracting and disputes. This, I suppose, in certain circumstances where the UK is concerned, may just add another degree of attractiveness to it and into the balance, which every party, when they enter into contracts and choose their dispute resolution mechanism, has to consider.
Okay, so now let's switch gears a little bit and let's look at how arbitration plays a role in the Brexit process, and in particular, as we discussed earlier, disputes regarding the TCA with the countries that have signed, so with the EU and the UK. So why don't we turn and talk about that, and just tell us what does the TCA say about dispute resolution?
So as I said, and as your printer will testify from the on it by the TCA, it's a very lengthy and exhaustive document. It covers all sorts of areas, and many of them are contentious, difficult areas, and also it leaves gaps. So there is going to be friction. There's going to be differences of interpretation. And so it's very important, and it's recognised up front in the TCA that it has to have what they term an efficient and effective dispute avoidance and settlement mechanism. And to achieve that, the drafters have agreed that international arbitration is the way to go. So there's an arbitration mechanism provided for state-to-state arbitration between the EU and the UK under and pursuant to the CCA. So it was a somewhat important and fraught area of the negotiation itself providing for this. The EU, I think, would have preferred the Court of Justice of the EU to be the determining body for these disputes. The UK felt it was very, very important that an independent body and an independent process would be put in place. And so this was sort of a negotiation victory for the UK, this particular point and process.
Let me ask a little bit about that. If you know, why did the EU want their courts to be the decision maker, and why did you guys not want that? I mean, I think it's probably obvious, but why don't you address that?
Yeah, well, I mean, I think naturally, each side wants what's basically termed home court advantage. Right. The EU is very, very used to the process of the Court of Justice in how it conducts its reasoning and how arguments are presented in front of it, and so on. And there's a long track record and familiarity. And I suppose to a degree that the UK felt perhaps there'd be a slight tactical disadvantage to a certain degree. But I think more importantly, it's the symbolism. As part of Brexit, the whole the mandate of the referendum and Boris Johnson's promise was independence. It was the UK on its own. And I think the idea of perhaps being subject on some of these tricky disputes to decisions of an actual institution of the EU itself kind of would have undermined that independence message to a degree. So it was very important for the UK.
Okay, that's good to know, good and helpful in understanding. And I guess, and for this point, I guess the UK had the relative bargaining power on this point.
On that particular point, I'm not saying we won everything. Right.
Okay. So how will disputes be resolved? So tell us a little bit about that.
So it's a fairly detailed process, but in summary, there's two initial stages. There's consultation, and then there's arbitration. So consultation is sort of 30 days, pretty swiftly, and then there follows an arbitral process, which we can talk about in a little more detail. But the important thing is it's pursuant to the principles of international law. So again, and perhaps this was important for the UK in negotiating it, it's not the domestic law of either party. So it's not as if the EU gets to apply its own law. Equally, the UK doesn't. It's international legal principles. And it generally applies to most disputes under the TCA. There are one or two exemptions and carve-outs, which I don't think are important for this discussion. But it is the core dispute resolution process.
Okay, so you mentioned the two steps, and you mentioned the consultation stage being the first step. So essentially, consultation, from what I understand, is mediation, essentially. But why don't you describe that in a little more detail?
I think that's exactly right, Chucky. Save for there's no third party at this stage. It's just simply the two parties get together. Now, it's a limited time period, so it's 30 days, unless they agree otherwise. And it's without prejudice, good faith, confidential discussions aimed at resolving the issue. And it's only as if at the elapse of 30 days agreement hasn't been reached that we then move on to the next stage, which is arbitration. Okay.
So actually, I didn't realize that there's no neutral in the process. It's just the parties getting together. But is there? I assume that you can't have one though, right? That's not something that's prohibited.
It's not prohibited. It's not locked out. So the parties can they can extend the process, they can augment the process, and so on. And say quite interesting proposal you had there, perhaps bringing in a neutral to assist in that process at that stage, and indeed, that could be a good idea and could be useful.
Okay, and so hopefully some of your officials are listening. But we over in the US can help in that process.
Oh yeah, maybe.
Right. Okay, so let's talk about assuming that there's no resolution during the consultation stage. Let's talk about the arbitration process.
So that's right. So at the end of that process, there's no resolution. So one or other of the parties can then take it to the next step, which is submitting a written request for arbitration. So that identifies the particular issue or measure which they consider is not in compliance with the TCA, explains the basis of their view with regard to breach. And then the next stage is to convene a tribunal to determine that.
Okay. And the tribunal is there's the tribunal is how is it? Is the typical 3 arbitrators? I mean, how's the tribunal going to happen, or how's it set up?
Yeah, that's right. So there's three arbitrators, one of whom sits as chair or presiding arbitrator. There are certain requirements with regard to expertise and experience in international law, and there's the process for the parties to either agree those. And that's again by discussion. They can simply select and agree the tribunal members they consider appropriate. But in default of that, there's then a selection process from a number of sublists, which will be maintained of appropriate candidates. Now, one interesting thing is the sublists aren't in place yet. So if there's a tomorrow and the parties aren't able to agree the tribunal, there's a degree of uncertainty as to precisely how that tribunal will be nominated. But the idea is there'll be sublists and a process for selection of that, so that a tribunal can be convened regardless of the fact that the parties can't agree. Okay.
And as far as the rules and the duration of the arbitration, it seems like the way it's set up in the TCA is it's supposed to be a very short, truncated process to reach a decision. Can you describe that a little bit?
But that's right. So there are the rules of procedure for dispute settlement that set out the various procedural rules and so on. And as you mentioned, a key factor of that is they try to aim to progress things pretty swiftly. So there's a 160-day process for the whole arbitration to take its course, which I'm sure from your experience, on big complex disputes, that is a pretty ambitious timetable. So it'll be interesting to see how that goes. There's also a process for matters of urgency, and that's the defined term, but there's no actual underlying definition for that. So it remains to be seen how that's interpreted. But for the time periods to be halved, so we're looking at an even more expedited process.
Okay. Now we talked about the process, we talked about the rules, we talked about kind of how you set up the tribunal. Now let's move to hearing, award, and enforcement. How do those things play out under the TCA?
So it's interesting what you say about the hearing. The provision is that, again, subject to agreement, the hearing takes place in the opposite, essentially, home territory of the complaining party. So, for instance, if the UK raises the complaint, the hearing will take place in Brussels and vice versa. When the process proceeds to the decision phase, the tribunal issues its decision with regard to the measure which is being contested, and that is binding on the parties. The process then moves to the compliance stage. Now, the underlying principle is to avoid there being a need for unilateral measures or sanctions with regard to the breach. And so the process unfolds whereby the tribunal identifies a breach if it has found one, and directs the party in breach to take necessary measures to bring itself into compliance. Now, at that point, the party would then take those measures, and there is a process then for review. So there's the tribunal, if the other party is still not happy with the measures that have been put in place, tribunal can review that, consider the degree of compliance, and in the meantime, the complaining party has one of two temporary remedies to choose from. They can either choose temporary compensation, or which is to request compensation from the other party for the breach, or to select suspension of obligations. So that essentially allows them to, for instance, impose tariffs or set quotas on certain imports and so on. by way of retaliatory measure. Now, the idea is that they are temporary. What will then happen is the tribunal can review compliance again. If compliance has by that stage been achieved, those measures are then lifted, and the parties go on in their relationship. If the tribunal directs and finds that the measures have not been adequate or have not been implemented in the way that the tribunal has directed, these temporary sanctions can then stay in place and will continue until the party against who the tribunal has made its award has fully complied with the tribunal's decision.
Okay, it's kind of interesting. It will be interesting to see whether these arbitration tribunals, the panels, will really want to sanction these states. It's gonna. I don't know. Do you have a feeling about that? About whether that's really going to be a hammer?
Well, yeah. I mean that is interesting, but I think that the key factor about this is really it's actually the party, the wronged party, as it were, who gets sort of first choice in imposing what they think is an appropriate sanction, and it's then for the tribunal to review it. And I think that structure really sort of touches on that very valid point you make, is that tribunal members, and particularly tribunal members who are going to be appointed repeatedly because they're going to be on these sub lists, are perhaps going to be a bit reticent about pushing one or other of these powerful sovereign entities too hard. But the fact is, the wronged entity essentially gets first choice of implementing what they consider to be an appropriate measure. That's then subject to review by the tribunal. So the tribunal can then avoid or mitigate, perhaps excessive reaction or sanction by one party or the other.
Okay, so I think we've exhausted discussion about a tribunal. But one thing I think is important to point out is who has standing under the TCA to actually have dispute in this tribunal or bring a dispute in this tribunal. You finish off with that? Yeah,
and so just to conclude, and I think you touched on at the outset, that at the heart of this, it's a state-to-state dispute resolution mechanism. And so actually the TCA is very clear that individuals, corporate entities, and so on, be they in the UK or in the EU member states, do not have standing. So there will no doubt be instances where corporations feel they're unfairly impacted by quotas, various trade restrictions and so on, perhaps barriers which they feel are in breach or not in compliance with the TCA. But in those scenarios, what the best they can do is essentially lobby their government. So either lobby the EU if they're based in a member state, or lobby the UK government in the UK to bring an action for under the TCA under this process. What is not going to be the case is for individual corporations, individual entities of any nature outside of government to have standing to bring claims themselves.
Okay, well, thank you for that. So I think we'll probably conclude at this point. I just from my perspective, I mean, Brexit is always interesting, and anytime I get a chance to learn more about it, it's always nice to hear. I mean, as I said before, it seems like a lot of the structures are in place to make this a seamless transition. As far as the state arbitration, it seems like it's just going to be kind of the typical arbitration. So it seems like things might be a little different. Maybe you have more international arbitration because of the uncertainty in the English course we talked about. But it seems to me that, is there going to be a sea change? I'm not sure. I mean, I don't think so from what I'm hearing so far. But what's your conclusion on those things?
Yeah, well, that's right. Certainly the aim behind the negotiation and as I said in the introduction, this went right to the wire with getting this vast 1,200-page agreement put in place. The underlying aim was to avoid friction, was to make things as seamless and smooth and predictable as possible for businesses. And I think it's a credit both to the UK and to the EU that this, from the terms of the agreement, I think has largely been achieved. There is a lot of clarity, and things are continuing largely as they were before. However, there are also, there's always the potential for friction, for disputes, and so on, and potential uncertainty, which wouldn't have been there otherwise. I think the underlying point and the importance to restate of international arbitration is having those mechanisms for commercial disputes, having the state-to-state mechanisms in the TCA, just shows how arbitration and the principles and the process and the practitioners are of such continued importance, as we continue to navigate 2021 and beyond, and all the uncertainties that it brings.
Absolutely. Well put, and a nice way to conclude. So good to talk to you again. First time on this platform in 2021. We'll be back soon. There's a lot of interesting things to talk about. So look forward to it.
Thank you so much. Looking forward to catching up again soon. But thanks very much, Chucky.
Thank you.
We hope you enjoyed this podcast. If you have any suggestions for topics or want to reach Kwadwo Sarkodie or Charles Harris, you can find them at the Mayor Brown website, mayorbrown.com. Also, to learn more about other Mayor Brown audio programs, please visit mayorbrown.com/podcast. Thank you for listening.